Here to explain this lawsuit is Daniel Suhr, an attorney for the Liberty Justice Center, which filed the lawsuit. And to weigh in on the impact this amendment has had on Catholic schools is the principal of St. Anthony of Padua Catholic School in Greenville, South Carolina, Mary Margaret Martin. Thank you so much for joining me, both of you. Daniel, let's start with you. Can you give us a brief explanation of what Blaine amendments are?
Absolutely. The Blaine Amendment is this racially and religiously discriminatory constitutional provision in South Carolina that's sadly emblematic of constitutional provisions in states across the country. In the late 1800s, there was a wave of immigration coming to the United States from places like Ireland and Poland and Italy. It was overwhelmingly Catholic, and unfortunately, it sparked a shameful nativist response. And this anti-immigrant sentiment became embodied in a movement to bar public funds from going to Catholic and other religious schools that would serve these new immigrants. And so across the country, over 35 states adopted these so-called Blaine Amendments, named after their national champion, a long-dead congressman from Maine called James G. Blaine. They adopted these Blaine Amendments in about 35 states, and a lot of them, including South Carolina, are still on the books over a century later, and they are still preventing Catholic and other faith-based institutions from having equal access to educational funding. That's a shame, and it's why we brought this lawsuit.
It is a shame. Mary Margaret, why did your school think it was necessary to fight the South Carolina Blaine? Are you being denied COVID relief funds?
We are. And during these precedented times of COVID and having to the students to go face-to-face or virtual, it has just been really difficult for the school just to maintain its financial stability. We need these funds. We need equal access to everything, and we need just a level playing field for all of the students, regardless of religion and race.
And
the
Mary
students
Margaret,
are actually open.
Sorry, were your schools open right away? Did your schools open in the beginning?
We did. I'm at a school that serves African Americans, primarily poverty and below, and we were able to go ahead and in August go ahead and introduce a in-person learning, the full school day with face-to-face instruction in the classroom. So it was ideal for our students, because with the students needing this time from their parents so the parents could work, we had to go ahead and make sure that we were providing a safe and stable environment for them. So because of all of the extra necessities that we had, sanitation, new computers, lower class size, we are really in a bind, and we needed this money so that we were able to provide that safe and loving environment that our students deserve.
I'm sure those children really were appreciative of that. Daniel, really quick, from a legal perspective, what did the recent Supreme Court decision that was set to strike down Blaine amendments last summer actually do, and is it useful to you here?
Yeah, absolutely. Last summer, the Supreme Court decided a case called Espinoza versus Montana, and it laid down a fundamental principle of First Amendment law. States cannot discriminate against faith-based institutions simply because of their religious faith. That should be obvious, but it took a Supreme Court decision to lay that law down for the country. South Carolina is a little unique. Along with some other states' Blaine amendments, it bans funding for both private secular and private faith-based schools. So our case is the next extension, the next step that comes after Espinoza, and we really need to fix not just some of the Blaine amendments. Espinoza was a great start, but we need to fix all of the Blaine amendments and wipe this religious bigotry off the books in every state, including South Carolina.
Thank you so much, Daniel. We look forward to watching you do that. Thank you for joining us, Mary Margaret, as well.